doctrine of discovery, this charade of showing up at someone's house and saying, I'm superior to you and I get it, or I get some ownership interest in it, it's still the law in the United States. So, wow. What else did it do to tribes? Well, the court said it also limited some of their sovereign powers, and their commercial rights, and their international diplomatic rights, because now they were not supposed to engage in international activities. They were only supposed to deal with their discoverer. And again, in that second Marshall case that I've cited twice already, Cherokee Nation versus Georgia, Marshall refers back to this part of the doctrine of discovery. He said, why, if any other country tries to deal with our Indians, he says, our Indians, we would consider that an act of invasion and war. So no other country was supposed to mess with our Indians, the ones that were inside however many states we had in 1823. Wow, the doctrine of discovery. Now, I was going to continue to beat on Columbus, wasn't I? So some of this I've already told you about. Jefferson called this the right of preemption. Like I told you, the Johnson v. McIntosh case developed this title that we call it today, the doctrine of discovery. But Jefferson called it the right of preemption. And I give 1792 because he was our first Secretary of State. He was the Secretary of State. He was the Hillary Clinton of his day. In 1792, he's Secretary of State. He has a meeting with the British ambassador to argue about British troops that are still south of the Great Lakes and the Hudson's Bay Company that is still in there taking furs and trading with the Indians. So Jefferson meets with Sir George Hammond. What a good lawyer he was, folks. Because you can read the notes in advance. He wrote down the 6 things he was going to say to Sir George Hammond. The moment he gets home from the meeting, he writes down what they talked about. Yes, I covered those 6 points. And then he writes a letter, a confirming letter to the British ambassador. Thank you for meeting with me today. Here's the 6 things we talked about. Well, that's what lawyers are taught to do. That's how technical and exact we are taught to be. So Jefferson called it the right of preemption. And this conversation that he and the British ambassador had, which Jefferson records and you can read in his writings, and I can quote you some of it. Jefferson says, you got to get your troops out of there. They're still in Fort Detroit. They're still in Fort Machillaneck. The Hudson's Bay Company's in the Ohio Valley. And Jefferson says, you got to get out of there because those are our Indians and our territory. And the British ambassador goes, well, what do you mean? What are your rights vis-a-vis these Indians? And here's what I can quote you. Jefferson says. He says, why, sir, we have the right of preemption over them. And the British ambassador pretends he doesn't know what that means. And he goes, why, sir, what's this preemption? And he says, why, we're the only country that can buy their lands. We're the only country that can trade with them. We're the only country that can sign treaties with them. You've got to get out of there. So see, Jefferson, in 1792, knew the exact definition of the doctrine of discovery that the court didn't come to until 1823 in Johnson v. McIntosh. And so in my book, I also point out how the doctrine of discovery was part of the laws of our colonies, those 13 colonies. There's only a few court cases from back that long ago, but you can see the doctrine of discovery in some of these court cases and in what the executive branches did. Our state governments. Why, gee, no wonder Jefferson knew a lot about the word preemption. You know, he wrote the first state Virginia Constitution himself in 1776. He wrote the first draft the Virginia State Constitution. And Virginia claimed the right of preemption over all Indians within the Virginia colony now / state. Our founding fathers knew what this was about. Today we don't. Again, it's sort of like just there's not too much land to find, and who thinks about something like that anymore? But this was the law of colonization, expansion, conquest. This was how it was done. And what we would just call a joke today meant something legal and transferred this right of preemption, the word Jefferson used, that became the word doctrine of discovery, which is what Russia did in 07, China did in just a few months ago, and in essence, why our flag's on the moon. I mean, is it to prove just we were there? Yeah, we're kind of proud about that. That's good. Leave a souvenir that it was us that did it. But if there's something to have there, something to own, we're claiming it, whether there's moon people or not. Well, I barely have. Okay, I got to tell you this. this part. You've probably all read that the Louisiana Purchase was the greatest real estate deal in history. Has everyone heard that? The history books say that. We paid 3 cents an acre. That's an absolute lie. I'll prove it to you from Thomas Jefferson's own mouth. If he was alive today, would he get a belly laugh to see how wrong the American history books are? And everyone that writes about the Louisiana Purchase repeats that canard that it was the greatest real estate deal in history. Well, it was not. We did not buy the land in that yellow area on the map. 800 million acres, folks. And we paid France $15 million, right? Doubling the size of the United States. But did we really buy the title to the land? Did we acquire the fee simple absolute title from France? And I'm going to show you in a second, Thomas Jefferson says, no. What did we buy from France, you think? Pardon? Thank you. Good student, you get an A for the day. We bought the right of preemption, this option that I described with the lady here. That's a perfectly legal property right still today under our law. That's what we bought from France. In fact, folks, a very famous author, Felix Cohen, wrote a large article in 1947. I'm not telling you anything new. He wrote it in 1947. He calculated how much the United States paid the tribes in the Louisiana Territory. Just take a wild guess. In treaties that we signed with tribes, in agreements we made with tribes for the next 100 years after the treaty, we paid the tribes $300 million. So what we paid France was just to acquire this option, this right of preemption, which is a legal right. That's why we paid them. And then France sailed away. Folks, the treaty we signed with England that ended our Revolutionary War, guess what England granted us south of Canada? The Treaty of Paris, 1783, or maybe it's the Treaty of Ghent, 1783, that ended our Revolutionary War. It didn't set out any boundaries. There was no fancy language about what we acquired. It just says England gave us all its proprietary rights south of Canada. Well, what proprietary? That means ownership. What ownership rights did England have in the Ohio Valley and from the Mississippi to here? Well, in 1781, England had no rights except the doctrine of discovery, except the preemption power. So that's what England granted us. That's why Jefferson was having that debate with the British ambassador why English troops and the Hudson's Bay Company were still south of Canada. It was now supposed to be U.S. exclusive territory, and the Indians were U.S. exclusive, I don't want to say property, but U.S. exclusive subjects, really. That's what they were debating in that conversation I told you about earlier. So what did we buy? The doctrine of discovery. And how am I going to show it to you from Jefferson's words? Well, I'll show you a letter he wrote to the Congress in 1808. And I don't even have time to get into it. In 1804, he spent the summer of 1804 at home at Monticello writing a 40-page pamphlet trying to figure out how big Louisiana Territory was. And he used the principles of discovery that defined the territory, that defined the Oregon countries. Jefferson even tried to claim that the Louisiana Territory went all the way to the Pacific Ocean. He wanted the Pacific Northwest, and he hoped that the Louisiana Purchase would also somehow include that. Okay, I digress. But if you ever want to read an interesting 40-page pamphlet, I of course describe it in my book, so that just buy the book. But in 1808, late in Jefferson's time in office, he writes 5 letters to the Senate and the House. And he tells them, oh, I've softened the Indians up, and they think I'm their friend. And he says, I think we can start buying more land from them. Because for a few years there, he was so greedy to buy land from tribes that for a few years, the Choctaw, Chickasaw in the southeast, they refused to sell him any more land. They just ran off the American treaty representatives. We're not selling any more land. But anyway, so Jefferson writes this letter. I've softened them up. They think I'm their friend. Oh, God. friends like that. But look what he says. He says, I think we can start buying land west of the Mississippi. West of the Mississippi is the Louisiana Territory. And look what he says. We have to buy the land from the native proprietors. I used my Oxford English Dictionary to be sure that the word proprietor meant the same thing in 1808 that it does now. And of course it does. Jefferson knew the Indian people were still the proprietors of the lands west of the Mississippi. In fact, I have 3 more minutes. In fact, Jefferson didn't think the Louisiana Treaty was constitutional, and he personally drafted a constitutional amendment that he wanted the Constitution to be amended to allow Congress to adopt the Louisiana Treaty. Very few people know about this because they kept it silent. His 4 cabinet members, primarily James Madison, his Secretary of State, said, my God, don't tell anyone you think that treaty's unconstitutional. But anyway, Jefferson's amendment, which is hard to find, but you can find it in a couple books now, he would have guaranteed, despite the purchase, he would have had the Constitution say that the Indian people in the Louisiana Territory still have the right to occupy their lands and to govern themselves. So Jefferson knew he was not buying the land from France in the Louisiana Treaty. So I hope I've convinced you. I mean, there's 2 points where Jefferson would get a real good laugh to read that we bought the Louisiana Territory for just that $15 million, because he knew we weren't. Now, how do we get this back around to Columbus? In 2 minutes. What did Columbus come to the New World for? To claim land. To become the admiral over any lands that he would acquire for the king and queen of Spain. That's what he was looking for. The riches, the slaves, new products, whatever. He, of course, made 3 more trips to the New World because they did make him the admiral. He was in charge for a while. What did he do to native people? Well, if you know about the Arawak peoples, the Tainos, on just one island of Hispaniola, there were 250,000 happy, successful Taino Arawak people living on that island the first time Columbus showed up. And in about 2 decades, there were 15,000 left alive. The Spanish chopped their arms off, chopped their hands off, enslaved them, killed them, diseases. Thanks, Columbus, let's celebrate that day. Well, maybe let's not. Anyway, it is part of our history. It's stuff we have to understand, but we need to know the truth about things. And understanding Johnson v. McIntosh and understanding what Columbus was out here to do was European expansion, European domination, European theft, European death and destruction. Okay, let's go eat. On that happy note, so I should leave us a little more upbeat. Well, you know, you look at history, sometimes you can't be upbeat, right? What's the old, I don't know what that old saying is. It's just what it is. Is that the old saying? Is that the saying now? Yeah. But we can fight against it. American Indian people can try to get out from under the thumb of the United States. This doctrine of discovery that's 400 years old, my math's not too good, 560-some years old. Pretty hard to reverse something that is that ingrained in American law, European law, and world law, and with Russia and China sticking their flags on the bottom of the oceans. So in my book, in the final chapter of my book, I have a pretty weak conclusion because I don't think American Indians are going to rise up with weapons and take back the whole United States. I mean, I'm not advocating that. That's not what's going to happen. Guess who has the atom bomb and guess who doesn't? So, I mean, that wouldn't even work, would it? So I have this weak little conclusion that Congress and tribes should work together and should try to back the federal laws away from the doctrine of discovery and away from the United States being the legal owner of tribal lands and telling them what to do with their land and how to live on it. And so we should slowly try to back away from this trust relationship where the United States, the Congress, and the President tell tribes what to do. And, gee, I'm coming in at a very weak conclusion. Anyway, thank you for being here. I would be delighted to talk to you more and answer, we can answer some questions, but of course we want to eat, and we're going to see a film, and other people are going to talk, so I'm delighted you're here. It's about 20 times as many people as I thought would show up, so thank you very much for being here.
People have